Hello everyone. Last time we looked at outlining the influences on Parliament, and this time we've got two topic learning objectives left to cover. And these are outline the parliamentary legislative process and assess the importance of parliamentary lawmaking. So before an Act of Parliament becomes a law, it's actually known as a bill. And a bill has a specific process that has to go through Parliament before it will become law. However, before we get to that drafting stage and something's written down, there's actually a pre-legislative process which we need to be aware of. The pre-legislative process. Before our law can begin life as a bill and enter Parliament, it first has to go through two stages. The first stage is known as the Green Paper stage, otherwise known as the consultation document. And what this means is that, as we've discussed in the previous video, the majority of parliamentary laws actually come from the government of the day. Perhaps the laws that they wanted to achieve, they mentioned in their manifesto, and then now in power they're able to actually put those into action. So, for instance, if we think about education, it might well be that the Education Secretary, currently Michael Gove, may propose reform to education and want to draft a bill whereby A-levels are replaced with a more rigorous qualification for 16 to 19-year-olds. And so it will begin as a green paper setting out the vision for that change, and then it's going to invite interested parties to give their opinions. Now, of course, being an education bill, and as I've said just now, A-levels, 16 to 19-year-olds, then obviously there are going to be a number of interested parties, not least students themselves, parents, teachers unions, and also employers. And they're going to have a range of opinions. Some are going to agree with the government, some are going to obviously be against it. So I can imagine, for instance, that it might be the view of some parents that A-levels aren't difficult enough and need to be more rigorous, and they would see it as a good sign. Employers might take the view that A-levels are trusted, they've existed for quite a long time now, is there really any need to disrupt that and cause confusion? And students might have mixed views, some of which might be A-levels are difficult enough as it is, we work hard, and why really do you need to put us through this change? So once all these opinions have been sent to the relevant government department, which is now done online, then a more detailed proposal for that law can be given, and then the green paper essentially becomes a white paper. And as you can see there with the image in front of you, it's just the law with a bit more detail. And at this point, it will be drafted into a bill and enter one of the houses in Parliament. There are three types of bill that you need to be aware of. The first, a public bill. These largely come from the government itself and concern public policy matters that will affect the whole country or a large part of it. A good example in your textbook of a public bill that then became law is the Constitutional Reform Act 2005, which amongst other things reformed the role of the Lord Chancellor with the judiciary and also created the new Supreme Court, separating from the House of Lords. You also have a private bill. These will affect an individual or corporation, and if you look in your textbook, a good example of this would be the Whitehaven Harbour Act 2007, which transferred all rights and obligations for the harbour from three separate companies to the Whitehaven Harbour Commissioners. And then finally, the hybrid bill, introduced by the government, but these will only affect an individual, corporation or place. And if you look in your textbook, the example you're given there is the Crossrail Act 2008, which allows for the construction of government rail links in London and will of course affect people in that area. However, it's important to remember that not all bills are introduced by government. In fact, a bill can be introduced into the House of Commons by an individual MP, and these are known as private members' bills. Now, there is a couple of processes in which this can take place. The first by ballot, and as you can see there, if I just highlight it, there's an image. Behind the Speaker's chair there's a petition bag, so 20 private members can actually have the opportunity, if they ballot, to present their bill in turn to Parliament. Now obviously this is limited, it only takes place, this type of debate, on a Friday, and realistically speaking only the first 6 or 7 members in the ballot have a chance of introducing their bill. Secondly, through the 10-minute rule, this is where backbenchers, those MPs who don't hold front bench positions in the cabinet and so forth, they can try to introduce a bill through the 10-minute rule where they can speak for up to that time, trying to introduce or arguing for the introduction of new legislation. Now obviously it's very unlikely that private members' bills are actually successful, because unless that individual MP can get cross-party or government support for the legislation, then it won't actually be able to go through the stages of the legislative process and pass through the votes. However, sometimes just having that particular issue debated about for the first time in Parliament and raising awareness about an issue can be seen as a success. So once the green and white paper stage have been completed and a bill has been drafted, it's time for it to enter the House. Now it can either be the House of Commons or the House of Lords. It doesn't really matter, but I think generally speaking the majority of bills begin at the House of Commons and then enter into the House of Lords. And so it's very important that the bill is drafted correctly. Obviously the government minister responsible won't do that, it'll be for parliamentary draftsmen who are skilled at that task, but it will be introduced into Parliament by the government minister responsible for the bill. Now obviously your textbook does mention the important point that knee-jerk legislation can be really dangerous. In other words, if there is something that the government are responding to and trying to rush through a law and it's not being thought about clearly either at the consultation stage or as we enter Parliament through the stages themselves when the bill gets debated, and obviously it can make for a really bad law that can have a number of difficult consequences, not least for the courts themselves who are trying to apply it. And that, of course, the example your textbook gives is the infamous Dangerous Dogs Act 1991. So now our bill's been drafted, the first stage that it's going to go through is in fact the first reading stage. Now the first reading stage, if we say the bill began in the House of Commons, this is where the government minister responsible will read out the title of the bill and its main aims. There really isn't anything more detailed than that, and leaves it open to the House to vote, and the other members of Parliament will be invited to vote by the Speaker. They'll either shout out aye, which is yes, in favour of the bill, or no if they're against it. Now if the bill is actually defeated at this point, then it won't continue. That's the end of the matter. Obviously if the Speaker can't determine who's shouting aye or no, then the members of Parliament will be asked to leave through 2 separate doors, and Commons officials known as tellers will count their heads, obviously through the aye door or the no door, and then that result will be relayed back to the Speaker to announce to Parliament. Now if in fact it does have a number of aye votes and is successful, it will go on to the next stage, and the next stage is the second reading. The second reading stage is incredibly important because it's the first opportunity really for a detailed debate about the principles of the bill, and members of Parliament there will want to discuss the implications of the bill, what it will mean for people, and obviously essentially an argument for and against whether it should continue. There is another vote that's taken. Again, if it's defeated, then the bill will stop, it won't continue, but if it has got a number of aye votes, it will continue to the next stage, which is known as the committee stage. Now the committee stage is where 16 to 50 MPs, cross-party, although I would say the majority of the MPs in this committee will come from the government if it's a government-introduced bill, but obviously you'll have other members of Parliament there from other parties such as Labour. And this committee stage, essentially they're all sitting around one big desk, and they are examining each clause of the bill in detail to see whether or not it's practical and whether or not it'll work, and if it doesn't, what changes are needed. So with that being said, the next stage is actually optional, but if there were any changes, then these need to be reported back to the House of Commons, if that's where the bill started, so that they can be prepared for the next stage, which is called the third reading. Now, the third reading, by the time the bill's reached this point, it's really almost a foregone conclusion, a formality, that it is going to go through. Usually the bill isn't debated, although I believe if an MP wants to raise a question about the bill, he can or she can do so, and then a debate might be had. But really, there's just going to be one final vote, and then it will pass on the bill to the other house. Now in this case, if it's begun in the House of Commons, it will go into the House of Lords. So with respect to the other house, the stages begin again. So if the bill reaches the House of Lords, it will go through first reading, second committee report and third reading stages. There are some exceptions which your book discusses, but really what we have to remember from the last video as well, when we talked about House of Lords, is the House of Lords is a non-elected body. The members in that house or chamber weren't put there by an election and aren't accountable, if you will, to the people. They've been appointed. So they actually have limited powers in how they can deal with this bill. They're there to scrutinise it, they're there to check that if it will work or not, but certainly if they find that it's in need of change, amendment, or it's not, or they don't agree with it, then all they can do is bat it back, send it back to the House of Commons, and that's why this image here probably makes a bit more sense now. It's known as ping pong, this process. This is because of the powers found under the Parliament Acts 1911 and 1949, which essentially says that the House of Lords can delay a bill, they can send it back for further debate and discussion to the Commons, but they can't stop it. Once it goes back to the House of Commons and those changes have been made, it will return to the House of Lords, and then of course the House of Lords will push it on to its final stage, royal assent. Royal assent is the last element of Parliament coming into play, where we have our monarch, the Queen, who creates the law, gives her approval to that law being created, and all she'll have in front of her is a short title and nothing more, and that will then become an Act of Parliament once it's been given. When the Act of Parliament will actually commence depends, really. Usually it used to be at midnight. It could be that it's written into the Act when exactly it will happen. There are indeed some Acts of Parliament even today, like the Criminal Justice Act 2003, where there are some elements that are active now and are in law, and there are others that still haven't taken effect yet. One last image, term, if you will, I want to draw your attention to: the guillotine, which isn't mentioned in your textbook. Now obviously, passing a law from bill stage all the way to royal assent, it can take a long time. It depends on the law being proposed itself, but usually anything from 6 months to a year. Now there are obviously, as we're going to see in the next topic, other ways in which you can get legislation passed through a lot quicker by avoiding Parliament, but there is a way to make it a little bit quicker, and that is through the guillotine process, and which is where a time motion is put so that each stage has a given time and date and the required amount of sittings that it can have, so it doesn't go past a certain deadline, and that obviously can have an Act of Parliament be passed a lot quicker. If you go to YouTube and you search for how a law is made, you're actually probably likely to come across the UK Parliament channel, which is a really good find. And there's two videos in particular I just wanted to draw your attention to that summarise a lot of what we're talking about. The first one, as you can see there, Making Laws, Where Do Laws Come From, Part 1, and then the one I mentioned just a minute ago, How a Law's Made. Now, rather than having to search for them on YouTube, I've put them on Moodle under the topic materials for you to look at, and when you have a few moments, please do, because it really helps illustrate what we're talking about. Okay, I'm just up into the top right corner now for a moment because I didn't want to obscure this article which I really wanted to show you. It's from the BBC News website. It's called Private Members' Bills, Which Ones Made It, from 2012. I think it's a really interesting read, and I've uploaded it to Moodle and within the topic materials for you to look at later. And I think what's really interesting about it is it gives a good account of the process of private members' bills and what actually it means. And I think this was really interesting. If I just highlight that a second. If another MP does not like the private member's bill, they can kill it off by continuously talking through the debate until the time runs out, and this is called a filibuster. And also, just to look a few more, it gives details of some bills through 2012 that actually did make it. And it does say here that, if I highlight this again, private members' bills, unfortunately, one of the downsides is they tend to be very unlikely to be passed into law, unless, of course, they can get cross-party support, and essentially what the MP is after is support by the government. And obviously then, with the weight of numbers behind that party, they'll be able to get it through the legislative process and the voting stages. But it's a really interesting article, and please do check it out. Unfortunately, there's a bit at the end there which is cut off. It says 2012 private members' bills which became law, and it gave some details. But what I've done is I've taken a screenshot, and I can show you that in a second. So I've taken a screenshot of part of the article that was missing, the 2012 private members' bills which became law, and I think what's really interesting is it gives some details of the MPs and the bills that they've put forward. And while it's unlikely that private members' bills, as we've seen, will succeed without cross-party or government support, we can see that some actually do make it through. So looking at the image in front of us, Richard Ottaway, the Act Scrap Metal Dealers Act 2013, purpose makes it harder for scrap metal dealers to sell stolen metals. And I can look at the one at the bottom, Sir Paul Beresford, Prisons Interference with Wireless Telegraphy Act 2012 allows prison governors to block mobile phone signals to prevent inmates from carrying out illegal activities while inside. So firstly, the advantages of parliamentary lawmaking. It's made by elected representatives, they're democratic, they act on our behalf, they represent us, and they're held accountable. So if we don't like what they're doing, then come the next general election, we can actually vote for someone else and get them out of Parliament and the House of Commons. Secondly, acts can reform whole areas of law, and as we've already seen, some areas of law are really complex. It's not easy to find or to understand certain pieces of law, and one Act of Parliament can consolidate all of that. It may very well come on the recommendation of the Law Commission. Thirdly, it allows for delegated legislation. This is our next topic, but in other words, Parliament hasn't the time to do everything, and so there are other people with more experience, if you will, such as local authorities who know their local area, and so laws for local areas are best given to them to do by transferring Parliament's power to them, delegated in other words. That's our next topic. Fourthly, it allows for consultation, so the process of a law before it even gets to a bill is that it's had input from interested parties, it's not just one person's vision all the way through. And lastly, law is certain and cannot be challenged, and this is something we'll be looking at briefly in the next area. Parliamentary sovereignty, in other words, it's not for anyone else to challenge an Act of Parliament, not even a judge who's simply there to enforce the law, so it's the highest legal authority in the land. So for disadvantages of parliamentary lawmaking, firstly, there's a lack of time for Parliament to be able to deal with all the reforms that are proposed. For example, the Law Commission in 1993 investigated the area of law, Offences Against the Person Act 1861, which deals with criminal law and details the offences of assault and battery and so forth. And the language used in that act, because of course it's 1861 that it was created, is quite old and archaic. However, since putting forward its recommendations for reform and a draft bill in 1993, there is still no movement or any sign of that act being reformed. Secondly, it's time consuming. Parliament, of course, only has so much time to deal with so many issues, and obviously the ones of great importance, such as education, transport, matters that will affect the whole country, national security, etc., are the ones that take priority. Thirdly, there's little time for private members' bills, individual MPs that are putting forward proposed laws. The government, because it has the full weight of the number of MPs that it has, having been voted in a general election, dominates that parliamentary agenda with what it wants to achieve itself. So unless, as we've seen before, the individual MP has the support of the government or a cross-party support, then it's unlikely that he or she will get anywhere. Fourthly, acts can be long and complex, as we've seen with one act possibly amending another act or having to be read in conjunction with another to see its full legal effect. And lastly, the law becomes complicated when it amends another, which is really reiterating that last point which I made. And finally, parliamentary supremacy, or sovereignty as it's sometimes referred. The accepted definition was by Dicey, a philosopher in the 19th century, and it's also given in your textbook. His definition has three elements. Firstly, that Parliament can legislate on any subject matter. So, for example, if our Parliament were to pass an act that said any Parisian in Paris who drops any litter will face the guillotine as punishment, then obviously in theory our Parliament can pass that legislation, but because of the sovereignty of France, their own laws and government, they're clearly not going to take any notice of it. Secondly, that Parliament cannot bind its successor or be bound by a previous Parliament. So the government of the day at the moment will be passing its own acts and so forth, but come a general election, should a new political party become government, then obviously they may choose to repeal or to amend any of the previous laws, and so they're not going to be stuck to follow them. And thirdly, Parliament cannot be overruled by others, so it's not for anyone else to say that an Act of Parliament's illegal. Now obviously we can say it, but we don't have the authority, and the Act of Parliament will still remain and have to be followed. In fact, a judge's role in court is that they are there to enforce the will of Parliament, so he or she may believe that the Act is wrong or not right, but it's not for them to actually interfere, and normally we'll just have to apply it as it stands. So we've come to the end of this topic now. Thank you for listening, and I'll see you in the classroom.